The courtroom fell silent, and then came the words no one expected. Gasps echoed off the marble walls as the judge leaned forward, adjusted his glasses, and delivered a ruling that seemed to shut the door completely. Reporters froze. Attorneys exchanged glances. And standing at the center of it all was Pam Bondi, calm, composed, but clearly facing one of the toughest moments of her legal career. What happened next turned the entire courtroom upside down. Let's break it down. It was a packed courtroom from the very start. Media crews lined the back wall, their cameras positioned carefully to capture every expression. Legal analysts filled the gallery seats, whispering to one another as they flipped through thick folders of case notes. Even seasoned reporters admitted the atmosphere felt heavier than usual. This wasn't just another hearing on the docket. The case had drawn national attention, not only because of the legal stakes involved, but because of who stood at the center of the argument. Former Florida Attorney General Pam Bondi. Bondi walked in with the confidence of someone who had spent years in high-pressure courtrooms. Dressed sharply and carrying a neatly organized binder of documents, she greeted colleagues with a brief nod before taking her place at the counsel table. There was no dramatic entrance, no unnecessary gestures, just quiet preparation. But everyone in that room knew the significance of the moment. The dispute centered on a clash between state authority and federal regulatory oversight. At its core, the case asked a fundamental constitutional question. How far can a state go in enforcing its own policies when federal guidelines appear to overlap, or even conflict? It was the kind of legal debate that could shape future interpretations of state power. When Bondi rose to begin her argument, the room grew still. Her voice was steady, controlled, and deliberate. She didn't rush, she didn't stumble. Instead, she moved carefully through each section of her presentation, as though guiding the court step by step through a carefully constructed blueprint. She began by outlining the constitutional framework that supports state sovereignty. She referenced the 10th Amendment, emphasizing that powers not delegated to the federal government are reserved to the states. From there, she transitioned into the specific statute at issue, explaining its wording, its legislative history, and its intended purpose. For nearly an hour, she laid out her reasoning with precision. She cited past rulings from appellate courts that supported her interpretation. She referenced legislative debates to clarify intent. She pointed out distinctions between this case and others that opposing counsel had relied upon. Every time she introduced a precedent, she connected it back to the central argument. The state had acted within its constitutional boundaries. Observers in the gallery followed along closely. Some nodded in agreement as she highlighted specific passages in the statute. Even a few members of the opposing legal team appeared to acknowledge the strength of her delivery, quietly conferring among themselves. What stood out most was her composure. There was no emotional appeal, no dramatic flourish. Her argument rested on structure and logic. Each point built upon the previous one, forming a chain that seemed difficult to break. As she spoke, the judge listened carefully, occasionally jotting down notes. His expression remained neutral, revealing little about his thoughts. That neutrality only added to the tension in the room. No one could quite tell which way the court was leaning. Bondi then addressed the opposing side's central claim, that federal preemption limited the state's authority in this area. She argued that the federal statute in question did not explicitly override state enforcement under the circumstances presented. In fact, she suggested that the law left room for states to act, particularly when federal standards did not fully occupy the field. It was a technical argument, but she made it accessible, breaking down complex statutory language into clear explanations. She emphasized careful interpretation rather than broad assumptions. The statute, she explained, must be read as written, not as expanded beyond its plain text. The courtroom remained silent except for the soft shuffle of papers and the faint hum of the ventilation system. Reporters typed steadily, capturing every phrase. By this point, it seemed Bondi had established a strong rhythm. Her argument flowed smoothly. Her confidence was evident. The structure of her case appeared solid. And then, just as she began transitioning into her final supporting point, the judge raised his hand. The interruption was subtle, but unmistakable. "Counselor," he said, leaning slightly forward, "let me stop you there." The shift in energy was immediate. Bondi paused mid-sentence. The gallery straightened in their seats. Pens stopped moving. The judge adjusted his glasses and glanced down at his notes before looking directly at her. "Your interpretation," he began carefully, assumes a level of state authority that may not align with established federal preemption standards. The words hung in the air. In that instant, what had felt like a steady, confident presentation encountered its first major obstacle. The judge's tone wasn't hostile, but it was probing, challenging, analytical. And everyone in that courtroom understood what it meant. This was the moment that could define the entire hearing. Halfway through her argument, the judge raised a hand. It wasn't dramatic, it wasn't loud, but in a courtroom, even the smallest gesture from the bench carries weight. "Counselor," he began evenly, "your interpretation assumes authority that may not exist under federal preemption standards." The room shifted instantly. You could almost feel the temperature change. The quiet confidence that had settled over the courtroom just moments earlier gave way to tension. A few heads turned, pens paused mid-sentence. The faint scratching of reporters' keyboards slowed as everyone focused on what was unfolding. Bondi stood still, hands lightly resting on the edge of the podium. She didn't interrupt. She didn't react visibly. But the significance of the judge's words was clear to everyone present. Federal preemption. Those two words have the power to reshape an entire legal argument. If federal law fully occupies a regulatory field, state action can be limited or even invalidated. And the judge was suggesting that her interpretation might be crossing that line. The judge leaned back slightly before continuing. He questioned whether her reading of the statute stretched beyond its intended limits. He pointed out that Congress had enacted comprehensive federal standards in this area. If those standards were meant to create uniformity across states, then allowing individual states to interpret authority broadly could undermine that purpose. He flipped through a binder, locating a case citation. In prior rulings, he said, referencing a federal appellate decision, courts have made clear that where federal regulation is extensive, state action must be carefully confined. The message was unmistakable. Was this one of those situations? With each point the judge raised, the pressure mounted. He highlighted specific phrases from the statute. He asked whether Bondi's argument relied too heavily on implied authority rather than explicit language. He questioned whether the subsection she cited truly carved out an exception, or whether it simply clarified administrative procedure. Each question wasn't just a request for clarification, it was a stress test. And every person in that courtroom knew it. Opposing counsel exchanged quick glances, their posture subtly changing. Where moments ago they had appeared cautious, they now seemed energized. One attorney leaned forward, pen in hand, ready to respond if given the opportunity. Reporters, sensing the shift, began typing more rapidly. Some even looked up to catch Bondi's reaction, anticipating visible frustration or hesitation. But she remained composed. Still, the weight of the moment was undeniable. Finally, after outlining his concerns in detail, the judge delivered the statement that sent a ripple through the courtroom. "I'm not convinced this argument holds under scrutiny." It was a direct blow. Not a rejection, not yet, but a clear signal of doubt. A few quiet murmurs could be heard in the gallery before they were quickly silenced. The judge's words lingered in the air longer than anyone expected. For a brief moment, it seemed as though the entire foundation of her case had cracked. When a judge publicly questions whether an argument holds under scrutiny, it signals potential weakness at the core. If the court ultimately found federal preemption applied here, much of Bondi's carefully constructed reasoning could collapse. The atmosphere tightened. One reporter near the back adjusted his glasses and whispered to a colleague, likely framing the headline already forming in his mind. Another attorney in the gallery shook her head slightly, as if calculating the uphill battle ahead. Opposing counsel sat straighter now, sensing momentum shifting in their favor. One of them began organizing documents, clearly preparing to reinforce the judge's skepticism. The energy on their side of the room had changed from cautious patience to quiet optimism. From the outside, it looked like the argument had been shut down. Bondi's earlier rhythm, steady, structured, confident, had been interrupted at its core. The judge's questions weren't minor technicalities. They went to the heart of her position, whether the state had authority at all. If that authority was missing, nothing else mattered. For a few seconds, the silence stretched. In courtroom terms, it felt much longer. Everyone waited for her response. Would she retreat? Would she concede part of the argument? Would she attempt to narrow her position? This was the kind of turning point that defines high-stakes hearings. The difference between a persuasive advocate and an overwhelmed one often comes down to how they handle moments like this. Moments when the bench signals doubt and the spotlight grows hotter. Bondi glanced briefly at her notes. Then she looked back up at the judge. The pause wasn't hesitation, it was calculation. Because in that instant, she understood something crucial. This was no longer just about presenting her prepared argument. It was about addressing the court's concern directly and convincingly. The courtroom remained completely still. What had seemed just seconds earlier like a shutdown was about to become something else entirely. What happened next was subtle, but powerful. In a room charged with doubt, where the judge's skepticism still echoed in the air, all eyes turned to Pam Bondi. She didn't rush to respond. She didn't interrupt the judge mid-thought. She didn't shuffle papers in frustration or whisper urgently to her co-counsel. Instead, she paused. And in a courtroom, a pause can be louder than words. She took a slow, measured breath. Her fingers lightly touched the edge of her legal pad as she glanced down, not searching frantically, but grounding herself. Then, she lifted her eyes and looked directly at the judge. That pause mattered, because it signaled control. It told the courtroom she wasn't rattled. She wasn't retreating. She was recalibrating. When she finally spoke again, her tone had changed. It wasn't defensive. It wasn't combative. It was deliberate, calm, steady, and precise. "Your Honor," she began respectfully, "if I may clarify." The phrasing was strategic. Not "you're mistaken," not "that's incorrect," but "if I may clarify." She wasn't challenging the judge. She was inviting him to take a second look. Rather than repeating her earlier arguments, which might have sounded rehearsed or rigid, she reframed the entire discussion. She acknowledged the concern head-on. "You're absolutely correct," she said carefully, "that federal preemption limits state authority where Congress has clearly occupied the field." That sentence did something important. It showed agreement on principle. She wasn't denying the doctrine. She wasn't ignoring precedent. She was showing the court that she understood the legal boundary. Then she pivoted. "But the question here," she continued, "is whether Congress did so in this statute, and whether the specific subsection at issue preserves limited state authority under defined circumstances." Now, the courtroom leaned in again. She explained that the federal precedent cited by the judge involved materially different facts. In those cases, she pointed out, the federal regulatory scheme was comprehensive and explicitly exclusive. The statutory language used terms like sole authority and uniform national standard. But in this case, those words weren't there. She carefully walked through the text of the statute, emphasizing specific phrases. She highlighted verbs. She underlined qualifiers. She drew attention to a subsection that had not yet been fully addressed during the earlier exchange. That subsection, she explained, carved out a narrow but critical space for state enforcement when federal standards did not expressly override local measures. "This is not a question of expanding authority," she said calmly. "It is a question of recognizing the authority that Congress deliberately chose not to remove." The shift in framing was subtle, but transformative. Instead of arguing that the state had broad power, she narrowed the lens. She focused on precision. She focused on the text itself. She explained that the precedent referenced by the judge dealt with statutes that created complete federal occupation of the regulatory field. But here, she argued, Congress had left intentional gaps, spaces where state action could coexist. She cited an appellate opinion that interpreted similar statutory language as preserving concurrent authority. Not dominant authority, not overriding authority, concurrent authority. That distinction mattered. As she spoke, the earlier tension began to evolve into concentration. The judge, who moments before had seemed unconvinced, began flipping through the statute again. He reread the subsection she had pointed out. His pen tapped lightly against the bench as he considered the argument. Bondi didn't rush. She didn't overwhelm the court with excessive citations. Instead, she slowed the pace. She made sure each point was digestible. She acknowledged that federal preemption is designed to prevent conflicting regulations, but she emphasized that coexistence is not conflict, especially when Congress has structured the statute to allow for state participation under certain conditions. Then came the key moment. She explained that the state's action in this case fell precisely within those preserved conditions. It did not contradict federal standards. It did not impose incompatible requirements. It operated in an area where federal law remained silent or intentionally flexible. The narrative was changing. What had initially sounded like an overreach now sounded like a textual interpretation debate. And textual debates are far more nuanced than accusations of constitutional violation. The gallery could feel it. Opposing counsel, who had seemed ready to capitalize on the judge's skepticism, were now flipping through their binders again. The confidence on their faces softened slightly. They weren't relaxed anymore. Bondi concluded this segment of her clarification with a steady reminder. Preemption requires clarity, and where Congress has chosen not to speak clearly, courts have consistently held that states retain their traditional authority. She stepped back slightly from the podium, not dramatically, just enough to signal she had completed her clarification. The courtroom was silent again. But this silence was different from the one that followed the judge's criticism. That silence carried consideration. And suddenly, what had looked like a shutdown looked more like a turning point. Bondi carefully walked the court through the overlooked subsection, and this time, she did it slowly, almost methodically, as if she were guiding the judge line by line through unfamiliar terrain. She directed attention to a specific paragraph buried deeper in the statute, one that hadn't been the focus of earlier debate. With calm precision, she read the language aloud, emphasizing key phrases, except as provided, unless expressly prohibited, and subject to concurrent authority. Those words, she argued, were not accidental. Legislatures do not insert qualifiers casually. Every clause carries weight. Every exception has purpose. She explained that this subsection preserved certain state powers in situations where federal standards did not explicitly override them. In other words, unless Congress had clearly and unmistakably removed state authority, it remained intact. That preservation language matters, she said evenly, because preemption cannot be implied lightly. It must be clear. The courtroom listened. Just minutes earlier, the atmosphere had been thick with doubt. Now, there was concentration, the kind that comes when an argument forces everyone to reconsider their initial assumptions. Bondi didn't stop there. She reached for a prior appellate decision, one that had addressed nearly identical statutory phrasing. The case, she explained, involved a dispute over concurrent enforcement authority between state and federal regulators. In that decision, the appellate court ruled that when Congress includes language preserving limited state participation, courts must honor that intent unless there is a direct and irreconcilable conflict. She summarized the holding carefully, highlighting the narrow but crucial interpretation that aligned with her position. The appellate court had not endorsed unlimited state power. Instead, it had recognized that shared authority can coexist within a structured framework. This, she emphasized, tapping lightly on the document before her, is precisely that situation. The courtroom, moments earlier tense with skepticism, grew quiet again, but this time with focus. The judge leaned back in his chair, reviewing the statute in front of him. He adjusted his glasses and reread the subsection she had identified. His earlier skepticism had not disappeared, but it had shifted into something else. Evaluation. Bondi continued, carefully building on the point. She explained how the state's action fell squarely within that preserved authority. The regulation in question did not conflict with federal law. It did not impose contradictory requirements. Instead, it addressed a specific gap, an area where federal guidelines were silent or left room for supplemental enforcement. She clarified that her argument was not about expanding state power beyond constitutional limits. It was not about challenging federal supremacy. It was about exercising authority that had already been granted, authority that Congress had chosen not to remove. There is a difference, she said, between conflict and complement. That distinction resonated. From the gallery, observers leaned forward. A few legal analysts quietly underlined passages in their notes. Reporters slowed their typing again, not because the moment lacked drama, but because it required careful listening. Opposing counsel sensed the shift. One attorney stood, attempting to interject. "Your Honor, if I may." But before he could continue, the judge raised his hand without taking his eyes off the statute. "I'd like to hear this point fully," he said. That single sentence shifted the momentum. It was subtle but unmistakable. Just minutes earlier, the judge had openly questioned whether the argument could withstand scrutiny. Now, he was signaling that it deserved thorough consideration. Opposing counsel sat back down. Bondi acknowledged the judge with a brief nod and continued. She walked through the timeline of the state's action, showing how it aligned with the preserved authority outlined in the subsection. She emphasized that the state had acted within defined limits, not beyond them. She pointed out that nothing in the federal statute expressly prohibited what the state had done. And where Congress has chosen silence, she added carefully, courts should hesitate before reading prohibition into that silence. The logic was crisp. She wasn't asking the court to invent authority. She was asking it to recognize what was already written. By the time she concluded, the structure of her case looked stronger than before. What had seemed, just moments earlier, like a fatal flaw, an overextension of state authority, was now reframed as a misunderstanding of statutory nuance. The debate was no longer about whether the state had defied federal law. It was about how carefully the statute should be read. And that is a very different battlefield. The energy in the room had changed. Observers later said this was the exact moment the courtroom felt it. That nearly invisible shift when doubt turns into deliberation. The judge closed the binder slowly and rested his hands on the bench. He did not announce a ruling. He did not signal agreement. But his posture no longer carried the same skepticism as before. Instead, there was contemplation. Bondi stepped back from the podium, composed and steady. She had not raised her voice. She had not dramatized the exchange. She had simply narrowed the lens and sharpened the focus. And in doing so, she transformed a challenge into an opportunity. What began as a potential collapse of her argument had become its reinforcement. The courtroom could feel it. The case was far from over, but the momentum had undeniably shifted. The judge did not immediately issue a final ruling that day. Instead, he looked out over the courtroom, paused thoughtfully, and acknowledged the complexity of the statutory interpretation at hand. He noted that the issues raised required deeper examination and requested supplemental briefs from both sides. That decision alone spoke volumes. It meant the argument hadn't been dismissed. It hadn't been rejected. It was still alive. For a case that, just moments earlier, appeared to be slipping away, that was a significant development. But what truly stood out wasn't simply the procedural outcome. It was the resilience displayed in real time by Pam Bondi. Legal analysts covering the hearing later emphasized something important. Courtroom advocacy isn't just about delivering a polished opening argument. It's not about memorizing case law or stacking citations. It's about adaptability. It's about what happens when the judge pushes back. It's about how an attorney reacts when doubt enters the room. In this case, the most powerful moment wasn't when Bondi cited precedent. It wasn't when she outlined constitutional principles. It was the quiet pivot, the shift from defending a position to refining it under scrutiny. That kind of adjustment requires more than preparation. It requires discipline. Under pressure, many advocates double down. They repeat their original points, speak faster, or become visibly defensive. But what unfolded in that courtroom was different. Bondi listened. She absorbed the criticism. And then she responded. Not emotionally, not aggressively, but strategically. Her unexpected comeback wasn't loud or theatrical. There was no dramatic exchange, no raised voices, no dramatic objections. It was controlled, technical, precise. And that's exactly what made it powerful. In high-stakes legal battles, credibility is everything. Judges are not swayed by volume. They are persuaded by clarity. When an advocate shows they understand the court's concern and can respond directly to it, that builds trust. That day, trust was rebuilt in real time, because a judge's skepticism can either weaken an argument or sharpen it. If the advocate falters, the doubt grows. But if the advocate uses that skepticism as a guide, identifying exactly where clarification is needed, the argument can emerge stronger than before. In this instance, what began as a seeming shutdown became an opportunity to refine the statutory interpretation, an opportunity to emphasize nuance, an opportunity to narrow the focus and reinforce the foundation of the case. By the end of the hearing, the narrative had shifted. The question was no longer whether the argument held under scrutiny. The question was how carefully the statute should be interpreted, and whether Congress had, in fact, left space for the state to act. That is a much more balanced debate. For viewers who later watched the courtroom footage, the turning point was unmistakable. It wasn't the judge's criticism that defined the moment. It was the response, the pause, the recalibration, the deliberate clarification. That sequence transformed the energy of the room. Observers described it as the moment the courtroom leaned back in, not out of drama, but out of renewed engagement. The skepticism had not vanished, but it had been met head-on with structured reasoning. And that's what courtroom advocacy at its highest level looks like. It's not about perfection, it's about resilience. Final thoughts. Courtrooms are often portrayed as places of grand speeches and dramatic objections. But in reality, they are arenas where preparation meets unpredictability. Even the most carefully constructed argument can face unexpected challenges. And sometimes, the most compelling moments happen after it looks like everything has fallen apart. When the pressure rises, when doubt is voiced publicly, when momentum appears to shift. Those are the moments that define an advocate's skill. Whether you agree with her legal stance or not, the lesson from this dramatic exchange is universal. Composure under pressure can transform a setback into a second chance. In life, just like in court, criticism can either shake your foundation or strengthen it. The difference lies in how you respond. On that day, in a silent courtroom filled with anticipation, we witnessed a powerful example of strategic resilience. What seemed like the end of an argument became its refinement. What looked like a collapse became a recalibration. And sometimes, that quiet shift is more powerful than any dramatic victory. If you enjoyed this breakdown of courtroom strategy and high-stakes legal drama, don't forget to like, subscribe, and share your thoughts below. What moment stood out to you the most? And which case should we analyze next?